The next case is State for Shepherd. Each party will have 15 minutes to present their argument. You tell them to reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
5 minutes.
Thank you. That will be noted. I will try to let each of you know when you get to about a minute left in your time, so that you can wrap things up at that point in time. So I have the time up here. You can see that. The arguments are being recorded, so when you come to the podium, please, number one, introduce yourself first. Stay behind the podium because it's being visually recorded, and we want to make sure we don't lose you there. And also that will help you stay in the microphone, so you'll be able to pick up and we'll get your recording. If you are referring to a child or a minor or a victim, please make sure you use initials or some other term so we know that person is not the full designation. Having said that, we've read your brief and are ready to proceed whenever you are.
Good morning, Your Honors. May it please the Court, my name is Lorain App.No. I represent Hezekiah Shepherd. Your Honors, our argument today is that Hezekiah's sentence is contrary to law because the trial court did not comply with its mandatory duty under Revised Code Section 2919B1, which requires the court to consider his youth as mitigating. Your Honors, we feel that we have addressed this issue very completely in our briefs, so I wanted to open it up to this court today if there are any specific questions.
No specific question, and I appreciate that.
Okay, well then we would reserve the rest of our time for rebuttal.
Thank you.
Good morning, Your Honors. My name is Matthew Kern on behalf of J.D. Tomlinson, the Lorain County Prosecutor. I represent the state of Ohio in this matter. I just want to kind of make sure that I'm not entirely sure why we are here today. Hezekiah Shepherd waived his right to appeal as part of his plain sentence agreement, except for potential issues of ineffective assistance of trial counsel or prosecutorial misconduct. The argument before the court today does not raise either one of those issues. It was part of the plea agreement. It was a bargain for consideration of the plea. The state dismissed stacking 3-year firearm specifications that took Hezekiah's potential mandatory minimum sentence from 26 to life down to 23 to life. As part of the consideration for doing that, there was an interest in finality, and B, a bargain for waiver by Hezekiah that he would forego any motion to withdraw his plea, any post-conviction petition, any appeal, or any federal habeas petition. And that's spelled out in a 7-page plea and sentence agreement between the parties, in addition to the signed plea sheets, which are common in Lorain County. Notwithstanding those very specific and detailed waivers, here we are. So my first issue is we should not be here. This appeal has been waived. The court should dismiss the appeal consistent with the Sixth Circuit's treatment of federal waivers that are substantially similar. We have not tried, as part of the state, to induce any waiver that is unethical. We have reserved within that plea agreement the right to raise ineffective assistance claims and the right to raise claims of prosecutorial misconduct. As to any other claim, just like the right to a jury trial, just like the right to cross-examine witnesses, compulsory process, or any of the other 11C rights that a defendant waives when entering a plea, a right to an appeal is statutory and is waivable. The defendant's claims to the contrary regarding public policy are simply an opposite. The second issue that I'm trying to wrap my brain around this morning is the sentence imposed was the minimum mandatory sentence allowed by statute. The claim advanced on appeal is that Hezekiah was somehow prejudiced, otherwise there would be no reversible error, that he was somehow prejudiced by the trial court failing to consider his age as a mitigating factor. But mitigating factors only have value if there is room for the trial court to impose a different sentence. And here there's simply no room to impose a different sentence. 292902, we know, says that the statutory sentence for murder is 15 years to life. The stacking firearm specifications that were in the indictment are covered by 2929-14B1G. The discharge of a firearm from a motor vehicle specification, because this was a drive-by shooting, is a 5-year specification under 2929-14B1C. And all of these specifications stack by law in the statute. So I'm left to wonder, where was the trial court supposed to do anything, even if you think that the court failed to consider the defendant's age, which was specifically noted at the time of the plea and sentence hearing. So the court was aware of the defendant's age, and it was also specifically covered by the agreement between the parties that this would be the jointly recommended sentence. And that's my third issue. This sentence was jointly recommended between the parties under 2953-08D1. So even if there was supposed to be some finding, which is not spelled out in the statute just says the court shall consider the age. Even if there was some finding that the court was supposed to make, it's built in to the agreed sentence. And as this court recently said, this year in State versus Nutter, when dealing with a consecutive sentence issue, that finding is no longer necessary to be spelled out when it's part of an agreed sentence. It's not subject to further review. And the 8th District also confronted our issue when dealing with this statutory mitigating factor in 2929-19. The 8th District has already dealt with this same issue in State versus Holman in 2023 Ohio 716. In that court, there was an agreed sentence, and the 8th District said that the trial court's alleged failure to review the juvenile consideration was not itself reviewable because the sentence had been jointly recommended by the parties. So again, there's nothing for this court to do. And we also know that the murder sentence itself is not reviewable as a statutory matter under 2953-08D3. As the Supreme Court confirmed in State versus Grievous in 2022, a sentence imposed for murder is, quote, not subject to review under this section, end quote. And there's no constitutional challenge here, right? Just like Grievous, this is purely a statutory challenge raised by the appellant. So there's no prejudicial error. He waived his right to appeal. The sentence imposes the minimum mandatory sentence the trial court could possibly have imposed, and the sentence was jointly recommended by the parties, further precluding appellate review. So unless the court has specific questions about the way that this plea agreement is written or the language or what effect that might possibly have on the appellant's claims, I would yield back the balance of my time and thank the court for its time this morning.
There are no questions.
Thank you.
You'll have your full 5 minutes for rebuttal.
Thank you, Your Honor. First, regarding the state's claim that Hezekiah waived his right to appeal, he has not waived his right to appeal. The United States Supreme Court said in Garza that, quote, no appeal waiver can serve as an absolute bar to all appellate claims. He cannot waive the entirety of his appellate rights. He can always raise jurisdictional issues regarding the transfer of juvenile or from juvenile court to adult court. He can raise ineffective assistance at counsel and issues that prevent a knowing, intelligent, and voluntary waiver of his rights. And he can also raise sentencing issues after a plea. Furthermore, he has this.
How is that relevant to our case here before us today? What are you?
Garza?
Yeah, what is he claiming? He's not claiming ineffective assistance of counsel, he's not claiming prosecutorial misconduct. So he didn't really waive all his appellate rights, he only waived certain aspects of his appellate rights.
Correct. So it allows this court to review his case. The state's saying that this case should be dismissed because of the appellate waiver, and we're saying no, it should not be dismissed. We do understand that plea agreements or guilty pleas preclude this court from reviewing certain issues, but not every issue, including this one, which was the trial court's failure to follow its mandatory statutory duty under 2919B1, which is a codification of Hezekiah's constitutional rights. So the state's claim that this is not reviewable because it is a murder sentence is incorrect.
Can I stop you for a second?
Yes.
How old was your client at the time of sentencing?
My client was 16 years old.
how old was he at the time of the offense?
16.
Okay, so he was 16 when he committed the offense and 16 when he was sentenced.
He was 16 when he committed the offense. I'm not exactly sure how old he was when the sentencing happened, because it happened after that. But it doesn't matter how old he was at sentencing, it matters how old he was at the time of the offense for these certain protections, constitutional, statutory protections to kick in. His case was transferred from the juvenile court to the adult court, but despite the fact that his case was transferred, he still gets the consideration of 2929.
Counsel, is opposing counsel correct that the sentence imposed is the mandatory minimum sentence required under Ohio's sentencing statutes for his offenses?
Yes, Your Honor, opposing counsel is correct, but there is still harm here, and I will tell you why. There was no consideration of his youth as mitigating at his sentence. There's no mention of his youth at all, nor was there a pre-sentence investigation report. There's nothing on the record about his age at the sentencing hearing. Hezekiah will go see the parole board someday, and what they look at is sentencing hearings. They look at pre-sentence investigation reports. There's nothing in the record that indicates that they complied with their mandatory statutory duty. And so that consideration would be lost to time. That's what the harm is that when he goes to see the parole board someday, which he will, under Senate Bill 256, that consideration of his youth will be devoid from the record. I would also point out this court's attention to State versus Bush, 2023 Ohio 4473, and State v. Spears, 2023 Ohio 187, both recent cases from the 5th District, in which there was a negotiated plea agreed sentence. In that case, the trial court failed to consider the youth of the child, and those cases, the 5th District reversed the sentencing and sent it back for a new sentencing.
And in that case, did they give the defendant the mandatory minimum sentence?
I'm not sure exactly what the sentences were in that case, but there can still be harm because the statute says shall. So the court just did not comply with its statutory duty, which in and of itself.
Counsel, once a defendant stipulates to a particular sentence as being justified, does the sentencing judge still need to independently justify the sentence?
Yes, Your Honor, because the statute says shall. It's a mandatory duty. The defendants can agree to sentences. We're not saying that can't happen. 2919 doesn't preclude the sentence that he got here, but it doesn't relieve the court of its mandatory duties under the statute. And I would also note that trial courts aren't required to accept pleas as they are presented to the court. They still have certain mandatory, statutory, and constitutional duties that they must fulfill. I will just reiterate again, this was a child. He was 16 years old, and that comes along with it certain statutory and constitutional protections, and we're just asking that, in this case and in future cases, that courts be held to that they do consider
Counsel,
that.
your time is up this time.
Is there any further questions? Thank you.
The court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of court and also available on the High Supreme Court.